Okay, well, good morning, everyone, and thanks for being here. My name is JC Cortez. I'm the Director of Training and Development here at Synergia's Metropolitan Parent Center. And thanks for being here for our presentation on guardianship and alternatives. Just a quick announcement in Spanish for our Spanish attendees. Muy buenos días a todos y gracias por estar aquí para nuestra presentación sobre la tutela y alternativas. Si desea escuchar esta presentación en español, por favor, oprime el globito al fondo de su pantalla donde dice interpretación y ahí usted podrá escuchar esta presentación en español, gracias a nuestro intérprete, el señor Rey Miranda. Si llega a tener algún problema con la interpretación, por favor, coloque esa información dentro de la charla para que podamos tratar de dirigirnos a eso y sí, corregir eso. Gracias por estar aquí y bienvenidos a Sinergia. All right, so before we get started, I just wanted to let you know that we are broadcasting today's event live on Facebook Live. So hello, everybody on Facebook. Thanks so much for joining us, and warm welcome to all of you. We are recording this, and a link will be sent to you in a follow-up email within 48 hours. So yes, if you have any questions for those of you on Facebook, please place them in the comment section, and we will be watching those throughout the presentation so we can make sure that we include those in the questions for our presenter today. A few words on Synergia. Synergia is a multi-service agency located in Manhattan, in East Harlem specifically, that has been supporting New Yorkers with disabilities and their families for over 40 years. We offer a rich source of information and training tailored for parents, including parents whose primary language is not English or who they themselves have special training needs. We help them participate more effectively in their children's education and development, and we partner with professionals and policymakers to improve outcomes for all children with disabilities. Synergia, which is Spanish for synergy, is one of New York City's 3 federally funded parent centers committed to serving people with disabilities and their families, with an added focus on communities of color and economically disadvantaged. We do that also in partnership with our collaborators at Include NYC and Advocates for Children. We're always uplifting each other's work, so happy to include them in this. Synergia creates innovative programs ranging from transitional housing for homeless families who have children with disabilities, to an after-school art program for children with autism in partnership with the Guggenheim Museum, and also an integrated transition program that creates a safe space for children with autism and intellectual developmental disabilities that are going through teenage years and want to discuss teenage topics in a more familiar setting. So that's just a few things that we do here. There's a whole gamut that I could go through, but hey. A few housekeeping notes. We are recording this and we will share a copy of the PowerPoint afterwards. So yes, it usually takes about 24 to 48 hours. So if you bear with me, I appreciate it. If you have any questions at any time, please, we want you to leave this presentation with a greater understanding on what guardianship and the alternatives are. If they're case-specific questions, for the sake of privacy, please keep in mind that this is a public forum and we are on Facebook. So if it is very specific, please keep those details and reach out to us directly, either myself here at the Synergia office or to our presenter if you wish to do a consultation with them. I do want to make a quick announcement. Even though Katherine is an attorney and works in special education law, this is not to be considered a legal consultation by any means. This is not legal advice. If you have any questions over anything specifically, please contact a lawyer, whether it's Katherine or not, but please contact a lawyer before making those decisions, especially such serious decisions like guardianship or anything that we're about to discuss. So I want to thank you for joining us for our workshop on guardianship and alternatives with my dear colleague, Katherine Aquino-Melendez. She's from the Cuddy Law Firm, a legal firm that focuses exclusively on special education law. Katherine has been an attorney with them at their Westchester office, and her practice is focused on special education advocacy and litigation, as well as special needs planning and trust administration. So thank you for being here and welcome back to Synergia, Katherine. I'm so happy you could join us today.
Thank you, JC. Thank you to all of you for participating and being part of this meeting. I'm just gonna try to share my screen now. JC, can you make me a host, please?
You are now a co-host. There we go.
You can see it okay?
If you'll go to the bottom and just do the presentation
Yes, yes.
presentation mode. Yeah.
Okay, good.
Perfect.
Okay, technical glitches. We're 2 years into all of this and we still are struggling.
It never
Well,
stops.
anyways, good morning to all. As JC indicated, my name is Katherine Aquino-Melendez. I am a senior attorney at the Cuddy Law Firm in Valhalla, which is located in Westchester, New York. And my practice is focused on the special needs planning, guardianships, and trust administrations at the Cuddy Law Firm. Our firm does specialize in special education litigation, but today we will be focusing on the guardianship, alternatives, and alternatives for individuals with disabilities in New York State. Okay, we do have offices in other states, but my practice is only focused in New York State. If there are any questions, we will hold those until the end as well. And I know that some of you had also relayed some questions in advance to JC, and we'll touch on those answers at the end of the presentation. Thank you. So the first thing to consider are advance directives. And maybe some of you have heard of advance directives. What are advance directives? Advance directives are documents that allow for an 18-year-old with the capacity to understand what they're executing to complete a power of attorney, a healthcare proxy, a Hipaa release, excuse me, a disposition of remains, and a living will. Now, when I say that somebody has to have capacity, that means that the person that is signing these documents has to really understand what they're signing, right? And understand that a power of attorney allows for another individual appointed as an agent to make business-like decisions for them. They can do transactions, they can go to the bank on their behalf, right? So that agent designated makes business-like decisions for an individual. A healthcare proxy allows for an individual to designate a healthcare agent to, again, make healthcare decisions for them if they were to become incapacitated, or if, let's say your child is away at school and they're 18, they break their foot and you can't access their medical information, right? Because the doctor at the urgent care won't speak to you because you're not their healthcare agent. This will allow for you to access your child's medical information. Same with the Hipaa release, right? A Hipaa release, we all hear about it when we go to the doctor. You sign a Hipaa release that allows for your medical insurance to relay information to, or for your doctor to relay information to the medical insurance to pay for the bills. And so a Hipaa release allows for both the healthcare agent and power of attorney agent to access medical information if necessary. A disposition of remains and a living will are two documents that we tend to leave for the older individuals that are executing advance directives because, a young 18-year-old may not be of the right mindset to determine how they want their remains to be disposed of. Literally, it's exactly what the name says, right? How you want your remains to be disposed, and if you have any special instructions of how you want that to be done, as well as a living will to make life decisions for you, your healthcare agent, in regards to artificial respiration, nutrition, and so forth. Okay, these documents are very important and they should be completed with an attorney. I would not suggest that you go online and pull templates of these from the internet. These should be executed with an attorney, and everyone should have these documents, whether you're 18 or older and you have the capacity to understand what these documents are. They're very important documents and allow for, again, an agent to be designated to assist you if you are unable to make any decisions at the moment. And I'm going to apologize. I do have some allergies. Supported decision-making. Maybe some of you have heard about supported decision-making. And again, this is an alternative to the guardianship. In New York State, supported decision-making is not recognized yet. There is a bill that has been, well, there's been a few bills passed. They haven't made it through. There's most recently, about 2-3 months ago, another bill was passed. And so we're keeping an eye on whether the legislator will make it law. But as of now, it is not authorized by law in New York State. With that said, though, there have been some guardianship petitions in the state of New York that have been denied because supported decision-making exists. Now, what is supported decision-making? And maybe some of you have heard about this. Supported decision-making is a group of people that come together to form a team for an individual with disabilities and helps that individual make decisions, right? So the one thing you have to keep in mind is that there is an agreement that has to be executed with the parties involved and the individual that is benefiting from this team. And so you all have to decide who's going to make specific decisions for that individual that is seeking the guidance from others. It's a nice alternative because it allows for that individual with disabilities to be able to really express what they want and their preferences. However, again, it is not legally standing in the state as of yet. And also it is not applicable to every individual. There are some individuals that may need a lot more support, and that's why a guardianship may be necessary. But again, it's something to consider. And it is, popular in the state. There are a lot of families that do seek to establish a team for their children. If you'd like to access more information, there's a website, supporteddecisionmaking.org, and it includes information about supported decision-making, laws that are applicable in each state. Probably about a year ago, it was authorized in about 22 states in the country. That number may have changed. And again, it's potentially going to become effective in New York State very soon. But you can always go onto the website, read about it some more, see some testimonials, and also some decisions of guardianships that have been overturned because of supported decision-making in place.
Katherine, really quick, you say it might happen soon. Like, what does that mean, you think, necessarily? I mean, I know legislatures can take forever and, but it seems like it's a growing movement. As you said, it's already effective in 22 states.
Mm-hmm.
Do we see New York jumping onto this really soon?
Yes. Yeah, so, I mean, I can't foretell exactly when it'll come into effect, but maybe by next year.
Okay.
It might be something that, we'll have to really, maybe next year when I do this presentation, I'll be confirming it's official in the state. I don't really know how long it'll take, JC.
And quick question also, like, can you discuss really quick, like, who might be a better candidate for supported decision-making instead of alternatives?
Yes.
Rather guardianship.
So usually, I mean, if an individual has a capacity, like I said, and they can really communicate and, maybe they're pretty high functioning on the spectrum, let's say. Then maybe you can have them execute advanced directives and also be part of a supported decision-making team, right? So I would say that maybe someone who's a lot more higher functioning can communicate, right? Can express what they want, what they don't want, can maybe take in a little bit more, control of their life. I would say that would be probably more of the individual that would be a candidate for supported decision making.
Okay, so somebody who not necessarily higher functioning, but with less needs, or can make more
Mhm.
better decisions on their own and with more
Yes.
independence.
And then, it's also up to the family, right? Because some parents, I mean, some parents come into to see me and they say, well, I want guardianship. And, we're very conservative planners at the Cuddy Law Firm. And sometimes when we assess the situation and the individual, you know, sometimes I even meet with them because they may present differently on paper, right? Like an IQ may not be the most accurate determination of that individual's capacity. And maybe guardianship is not the most appropriate way to go. And maybe sometimes advanced directives is a better option, right? Because still the parents have some say in that individual's life, but letting them be a lot more independent.
Understood. My colleague Kim Madden from Advocates for Children is joining us today, and she asks, how do you determine if someone has capacity to execute a power of attorney, or et cetera?
Yeah, so they really have to understand, and again, even if it's explained to them in simple form, they have to understand they have to make the decision of who they want to designate as agents, right? So if a parent comes to me and says, I want to be my son's healthcare agent, and I want to designate my brother as their alternative healthcare agent. Well, it's my responsibility to make sure that that individual actually wants these people designated as their agents. And there have been instances that individuals have said, no, I maybe want my dad to be my primary agent, but then I want my godparent to be the alternative. And I have to acknowledge that because obviously then they have the capacity and they understand that they're allowing specific people to make these decisions on their behalf if they need that help from someone else. It's a little bit of a tricky situation sometimes, and again we rely on evaluations, IQ scores. um, you know Sometimes we even interview the individual and really gauge what their capacity is.
And when you interview the individual, are you using like any sort of like formal evaluation in that process, or is it just kind of, how you feel, like a gut instinct, as?
Yeah, a gut instinct. There's no formal evaluations prior to meeting with the individual. We look over all of their former evaluations, IEPs, and really, kind of assess what they can do, how they, you know, how they communicate. Their, you know, I just kind of have to feel confident that they would understand what they're signing. And again, I the vice versa has happened, right? Sometimes individuals come in and say, I want my child to have advanced directives, but I may say, I don't believe that's appropriate for them, right? A guardianship is more appropriate. So it depends.
Okay. All right. Thank you.
Okay. So then we'll touch on Article 81 guardianships very briefly because this is more applicable to individuals. Like it was established more for the older individuals, right? Um, the demented person or the individual with Alzheimer's. It authorizes a court to appoint a guardian to manage a person's personal and or financial affairs if they can't manage it themselves, and it can be tailored to a specific area. So again, it's more for that individual that's in need of some assistance, but they can, maybe handle some affairs of their personal life, but then maybe need assistance with other areas. Um, One thing to keep in mind with 81 is that this is filed in New York Supreme Court. It is a lengthy proceeding. There is, um, you know, a full like trial involved. There's sometimes guardian ad litems that are appointed on behalf of the incapacitated individual to represent them. And, you know, it's up to the court sometimes to determine who's going to be the guardian for that individual. It's also very costly because, again, there's so much involved. And it's always recommended that if you will be filing an 81 guardianship, that you do so with an attorney. Now, some people may say, well, I know someone whose child is disabled and they have an 81 guardianship. In some instances, for example, if maybe there was a court settlement that required an 81 guardianship to take place, then of course you would have to comply with the court order. But typically, 81s are more for the individuals that are older or, mentally incapacitated due to an accident or a disease, for example, like Alzheimer's. Now, the 17A guardianship.
Sorry to interrupt you. Before you continue, though, can you just explain what a guardian ad litem is for those that might not know?
Sure. A guardian ad litem is an individual appointed by the court to represent the individual that's incapacitated. So it's basically an attorney on that person's behalf.
Okay. So that's not something that somebody would file to become. It's something that is assigned by the court at court's discretion.
Correct. And it's usually a temporary appointment during a proceeding. Even in 17A guardianships, for example, in Westchester County and in New York County, with the pandemic, guardian ad litems had been appointed. Last week, I believe I was in a guardianship proceeding in Westchester County, and the court never appointed a guardian ad litem individual to interview the person, right? Because you have to remember, with guardianships, you're taking away that person's almost not rights per se, but abilities to really make decisions on their own. With that said, though, you always have to keep in mind that you're acting in that individual's best interest and really trying to take into consideration what they would want. And if they can communicate, ask them. Maybe it won't be the best answer, right? So for example, you say, Mindy, would you, take your medicine in the mornings versus that night? Because in the morning, or, that way it's already in your system, and then at night you have other medication to take. And Mindy may say, well, no, I want to take all my medicines together. But the reality is that maybe some medications have to be taken at night, right? Versus in the morning. So again, you want to ask them and you want to take into consideration what their desires are, but maybe you may have to sway them into doing what's best for them. Does that make sense?
Yes, that makes better sense. And quick question though, especially since we're always since New York City is so diverse in terms of language needs and accessibility and equity, is interpretation and translation provided automatically in the courts here in New York State?
Yes, if interpretation is required, for an 81, you would have to make that request prior to proceeding, and for 17As as well.
Okay, thank you.
Mm-hmm. Okay, and so with 17A guardianships, this is more of the guardianship that was developed for petitioners or individuals seeking to gain access to become that individual's guardian. Was established in New York State. This is very special to New York State, as 17A guardianships, and it allows for a petitioner to ask the court to remain guardian of an adult child with disabilities once they've reached the age of majority, which is 18 in the state. Now, I said adult child, right? But let's say the parents are no longer around, and it's maybe a sibling that wants to seek guardianship over their sibling with disabilities, and that can be done, right? So it's for an individual with disability, developmental or intellectual disabilities over the age of 18, and the petitioner seeking to become that ward's guardian. And the ward is a term used by the court of the individual with disabilities. You can seek to manage that individual's person or property, or both. Now, something to keep in mind is that if you're seeking guardianship of the property, in addition to that person, then you would have to file annual accountings with the court. And some property would then be tied into the court's jurisdiction. Some property is not tied to the court's jurisdiction, right? If you have some custodial bank accounts, government benefits, those wouldn't be tied in. But it's important to keep in mind that the annual accountings are required to be filed annually if you are granted guardianship of the property. Now, guardianship of the person, in New York County, every year, the court sends out to the guardians a questionnaire to complete, just to kind of keep a status on the individual's health and status. It's not done in every court, and again, every court is different. And even some courts that have, for example, New York County's court has 2 surrogate judges. They both act very differently. One of them has everybody participate. She asks questions of even the ward, which can be frustrating to my clients sometimes, because maybe their child can't really communicate, or becomes frustrated when the judge is asking them repetitive questions. But you also have to keep in mind that they're also trying to ensure that this is appropriate for that individual. Okay, and that judge does not appoint a guardian ad litem, versus the other judge who does appoint a guardian ad litem, who does basically all the background work and then reports back to the judge. So the judge, it's a much quicker proceeding with that judge, because she's kind of made her determination by the time she comes into the chambers. Okay. But again, every court is different, every judge is different, and sometimes you're very used to one way with a judge, and then next month they switch it around. So you always want to try to stay up to date as to what the specific requirements are for every court. Now, something to keep in mind with 17A guardianships is that they're filed in surrogate court, and they were developed so that individuals can, can file it on their own, right? So really, you don't need an attorney for a 17A guardianship petition. However, some parents, some individuals come and seek our assistance because they've tried it on their own and they just can't get it together. Sometimes it becomes very overwhelming for them. Sometimes, things happen. Maybe the parents are not in agreement. Maybe there's separated parents and one of the parents does not want to file for guardianship versus the other one. So that becomes a contested guardianship. And in those instances, it is suggested that you seek legal counsel. Okay. The other thing to keep in mind is if you are in a situation that, maybe you're not a citizen of the state, or I'm sorry, of the country. And again, I bring this up because, like JC noted, we are in a very diverse state. And, that can be a little bit of an issue sometimes for some of the courts. Okay. Like I said, you can go onto their website and access all the information. There's some DIY forms that you can complete yourself and file them if it's not a contested guardianship. And you can always contact the court clerks. They'll help you and answer your questions. I joke, but sometimes they like individuals more than they like the attorneys calling them.
Wow. So the do-it-yourself forms, that's great. Yes. And the other question I was going to ask you was, I know sometimes we, and I'm sure we're not the only parent center, we get calls, asking for help filling out guardianship papers, which is just something that nobody really does.
Yeah.
Is there any place that you could send them that offers that type of free, typical, that free guardianship support? Because what we do here in New York is typically refer them to their borough developmental disability council, you
Mhm.
know. But is there another resource or someone that can, kind of do that?
Honestly, JC, the court clerks. Now, the only issue is trying to get a hold of them these days, right? Because with COVID, although the courts are back in action, sometimes it's hard to get a hold of these court clerks. But really, they're the ones that are willing to help you and they'll know how to guide you to answer complete these forms. Um, they're not very complicated forms, but I can understand why, for example, Stina or Gia would be a little hesitant to complete these forms for individuals. Um, but again, the court clerks are very helpful. They're usually, you know, bilingual individuals at the clerk's office that are available to assist. So you can always contact them.
Great to know. Thank you.
Mhm. So how do you apply for guardianship, right? Like JC indicated, there's a compilation of forms that need to be completed. The first primary one is the petition, and that we'll go through some of those: the consents, affidavits of the um, proposed guardians, the doctor's affidavits or affirmations, which should it be for a physician and a psychologist. Now, if you don't have a psychologist, you can have two physicians, one with a specialty in treating individuals with developmental and or intellectual disabilities. Waivers and consents, and then the OCFS form. Okay. So this is what the doctor's affidavit looks like. And you'll send this over to the doctor's office, have them complete it. Make sure that they complete it entirely. Obviously, the file number will not be completed because that's not designated until it's filed with the court. But every other question should be completed. Okay. Sometimes doctors forget to answer them because they're in a rush, or maybe they have the nurse complete the form, make sure it's completed in its entirety. Also, make sure that the doctor has seen the child or the individual with disabilities at least in the last 6 months or within the time frame indicated by the surrogate's court, right? Because as I stated prior, every court differs. Some require, 6 months. Some say within a year, it's okay. So just make sure you're aware of what the requirements are. Make sure that there's at least a reference to psychological testing within these affidavits, right? Because one of the questions is if you've reviewed any documentation or if you've conducted any evaluations or reviewed anything. And if they are referencing a specific evaluation or testing, make sure that you include a copy of whatever they're referring to, because that's acts as supportive documentation for the petition. Okay. Now the petition itself, this one is probably the longest document, and it is to be completed by the petitioners seeking appointment of guardian of the person, and property, or limited guardianship of the property, right? So there's questions to be completed. You include the respondent is the ward or the disabled individual's information. Okay. You'll include any residential facility information if they don't reside in your home, if they reside at a facility, any deceased individual. You'll also need to include death certificates if there's any parent that is deceased, and an original birth certificate of the individual you're seeking guardianship of. If you need to access, maybe get another copy of a birth certificate, you can go onto your local registrar's office. But they usually return the original birth certificate. By occasions, there have been instances that maybe it's never been returned but usually they're pretty good about returning the original birth certificate. Question 4, the bottom, the last question, right? If any adult siblings exist or live, and also if they're not being designated as standby guardians. You'll also have to include any property that the respondent has if you're seeking guardianship of the property, income, and benefits. Okay. Then standby guardians, who you're designating as standby guardians, and who are standby guardians. Standby guardians are the proposed alternatives to whoever is going to be the primary guardian, right? So the primary guardian or the petitioner can be one person. It can be co-guardians, so 2 people or even 3 people. Standbys, it can be one person, it can be co-standby guardians. Then you have alternative standby guardians, so even a backup to that standby, and a secondary alternative guardian. So you can have a whole, plan of proposed guardians in case one cannot act. The one thing to keep in mind is that when the guardians, right, that are designated by the court are no longer able to act either because of incapacity or death, the standby guardian next in line has 180 days to go and say to the court, I am available and ready to serve as so-and-so's guardian, right? Because their guardians are no longer able to act either due to incapacity or death, okay? And then you'll also complete who the doctors are that are completing the affidavits. You include their name on the petition and the date of their affidavit, and why you should be appointed guardian. How long you've known the respondent, your educational background, whether you've had any convictions or criminal charges, whether you have any addictions to narcotics or alcohol. And this is a little bit of invasive information, some people may feel, but it is because the court wants to ensure that you are going to be an appropriate guardian to that individual with disabilities, okay? Now the OCFS form, it requires for you to do a little bit of a brain game, right? Because it has you list your addresses 28 years back from the time you're filing. So it'll keep your brain sharp. It checks on child abuse, whether adults have been charged for child abuse, and if kids have been abused themselves. Okay, now a question I get a lot is when completing this form, let's say I was in another country. That's okay, include the information from the other country, but keep in mind again that there's no guarantee that there will not be any immigration issues that may arise from, especially the history of when this form goes to the capital, Albany, and the background checks are done. And I really can't guarantee what will happen, but it's something that we always advise people of, right? So that everybody's aware that there can be issues with immigration if there is any that may surface as a result.
When you say immigration issues, can you just be a little bit more explicit?
Yeah. So, if you're not a citizen, if you're maybe in residency, or you had some sort of, I don't know, you overstayed and then your green card maybe was expired or whatnot, right? So things can happen. And this scares people, right? Because you want to seek guardianship of your individual, but you say to me, I'm not legal in the country. I don't care about your immigration status. I really don't. And the courts shouldn't either. In fact, until recently, the courts started to ask New York, Queens County, and the Bronx sometimes ask for citizenship statuses, which the law does not require for them to ask, but they've been asking for that. So you have to submit proof of citizenship or residency. In the Bronx, we once filed a guardianship petition for these individuals that were not citizens of the United States. They were working on getting their legalization papers done. And the court rejected their guardianship petition and required for an individual that was a citizen of the country to petition with them. So they sought a relative that was a citizen to petition with them. But, it's something that can arise, right? And whatever backgrounds or, skeletons in the closet that you may have forgotten about may come up.
Okay, so maybe what would happen is that it wouldn't necessarily jeopardize the undocumented individual applying for guardianship. It wouldn't jeopardize them in terms of like being able to stay here necessarily, but it would require them maybe to find somebody who is a citizen to apply to petition for that guardianship.
Yeah. And also your first comment, I can't really say, that immigration issues won't arise, right? And that may result in that individual being removed from the country. I don't know that. I'm not an immigration attorney, but, we always like to make individuals aware that, sometimes things can come out from this, especially this document, right? Because this is one that's doing a background history on you. So I can't really guarantee anything.
Okay, no, thanks.
Okay. And so sometimes one thing with the OCFS is that sometimes standby guardians may be required, just like the first standby may also be required to complete that form. Some counties are now also requiring co-guardians that are not the legal guardian, so like not the parent of the individual, to get fingerprinted, whether you're in state or out of state. Okay, so waivers. Waivers are for the individuals that are not applying to be guardians. So for example, if a parent is not, you may say, well, how come? But, maybe some parents are divorced and maybe one of the parents is not very involved in that individual's life and says, you know what, I'm not going to petition because I don't really know my child's needs, but you've handled everything, you know what's right. I'm going to step back and you'll be the only guardian, and then you can designate whoever else as a standby or a co-guardian. So that parent that's not applying as a guardian would have to complete a waiver. Any adult siblings that are not being appointed guardians or standby guardians would also complete a waiver. And in some counties, the standby guardians as well. And this is what a waiver looks like. So it's basically renouncing your right to be appointed a guardian and that you're in agreement with the designations of guardians being proposed. Then there's a consent, and this allows for standbys and alternatives to be served. So again, the approval of all the designations and then waiving the consent to be served. Now, once you have all your documents completed, any supporting documents that you want to include, whether it be evaluations referenced in the doctor affidavits, birth certificates, any additional IEPs or evals that you want to throw in there, then you'll file that with the court. The court will issue a citation, and the citation includes the hearing date. You will serve that citation on the respondent, right, the child, and any interested parties, whether it's the individual's group home director, mental hygiene legal services, that was appointed for every individual. But when the pandemic hit, they became overloaded, and so they were only designated for the individuals residing in group homes. Then the court started to appoint guardian ad litems, Remember that term I used earlier today. The guardian ad litem still acted like the mental hygiene legal service attorney that would investigate the process, the petition, interview the petitioners, potentially interview the respondent, and ensure the court that the guardianship was appropriate. Sometimes you'll have to serve other individuals, maybe if they didn't complete the consent to waive their service. And then you'll file an affidavit of service with the court that you've completed all your service. Okay, there are service timelines. Depending on when the hearing date is taking place, you have to serve within a certain time frame. And this is what a template of a citation may look like. Sometimes the courts generate their own citations, but this is a template. And I'll say, wherever the county is. One thing to keep in mind is that you want to file for guardianship in the county where you reside and the respondent, or if the respondent, for example, resides in another county because maybe they're in a residential facility, then you may want to consider filing in that county versus the one you reside in. Fingerprinting, like I mentioned, some courts require fingerprinting to be done, even for co-guardians that are petitioning, but that may not be legal guardians. For some of the standbys, excuse me, you'll be required fingerprinting. The interview with mental hygiene legal service attorney or a guardian ad litem, depending on the situation. But like I mentioned last week, I was in a court appearance in Westchester County, and there was no one appointed. Then finally, the hearing takes place. Who needs to be there? That differs, again, county by county and court judge by court judge, right? Some judges may require for everybody to appear. I feel like that's been more of the trend now with the pandemic, that most of these hearings have been taking place virtually. And so I think the judges are figured, well, everybody can appear easier online versus when you would have to show up to court. So that's something that, you want to make sure that who has to appear and who's excused from appearing, because you don't want to show up and then not have the individuals that need to be present. And then finally, the court will order the guardianship determination and issue letters of guardianship. These are letters with a seal. Sometimes if you want, you can request more than one. There is an extra charge to that, but they are very important. You should keep them in a safe place and maybe give copies to, the co-guardians if they're not an individual that you reside with, or the standbys, okay? And so that's that. Any questions? JC, I know you had emailed me some questions, I believe Friday, so we can go through some of those too.
Sure. I know off the top of my head, one of those questions was, at what age can you start this process? And also, is it too late after the individual is 18 and achieve majority age?
Yes. So at what age? And thank you. That was a great question. And I can't even believe I skipped through that. You should definitely start the guardianship process around 16, 17, because ideally you want to avoid there being a gap once that individual turns 18. And you want to have that guardianship in place either right when they turn 18 or like maybe a few months right after they turn 18. So you want to start it as soon as possible. But, sometimes parents are like, oh my God, my kid is 17 and I haven't started guardianship. It's okay. It's okay. It will get done. It takes a little bit of time. Usually where you hit like the wall is when you're trying to get those doctors to complete those affirmations, because they're just so busy and, they kind of get a little overwhelmed. Sometimes they want to see the individual and get more up-to-date information, which, is totally understandable. But you want to have some time to complete everything, to do everything in time. Again, do not worry if maybe your kid is turning 18 in 6 months. You can get it done. The courts, though, are taking a little bit of time to process these guardianship proceedings because, like everything else, when about 2 years ago, when the pandemic started, the courts shut down, everything slowed down. So, they're picking up some movement, but it takes a little bit of time. Um, don't try to rush them. They're not going to rush unless it's an emergency guardianship. That it's going to kind of go with the flow of submission. Um, if your child is over the age of 18, that's okay too. You can still file for a guardianship. Some individuals file for guardianship when they're maybe like their sibling, right? Because their parents didn't have issues back in the day when their sibling was growing up, and now the sibling is left to care for the disabled sibling, but the disabled sibling is maybe now 40. You can still file for guardianship if need be, because maybe that sibling can access medical information, or is getting a hard time, right? Because some individuals give you a little bit of a harder time. Some parents say, well, I don't need to file for guardianship, right? My kids' doctors know me, and that's not an issue. Yes, probably, but they are responsible. They have there are ethical obligations to comply with doctors, and sometimes maybe the doctor changes, or you find yourself at urgent care where the attending doctor doesn't know you, and you can be in a situation, or you're in another state, or whatever the case may be. One thing about guardianships, 17A guardianships, is that they're plenary. So really, they cover everything. The one thing that they do not remove is that individual's constitutional rights. So, that individual, if they want to get married, they can get married. You cannot forbid them from getting married just because you're their guardian, right? Because they're still a human. If they want to vote and they have the understanding of what it is to vote and potentially make a selection on the Scantron, they can vote. It's not like a get out of jail free card either if you have guardianship over someone, right? Because I remember one time a client said, well, my child tends to kind of like grab stuff at the store just because his mind was very immature and he wanted like a piece of candy. Well, and she was afraid that maybe they would call the police on him. I mean, you can explain to, police officer, my child is autistic and doesn't really have the capacity to understand that they're stealing, right? Because they might have the mindset of a 2-year-old when they're like 25, but, it's not necessarily gonna be a free pass to do criminal acts. Does that make sense?
Mm-hmm.
So yes, that's a response and something extra for you.
Yeah, no, absolutely. And it's I mean, yeah, that's good to know. It really is good to know, because you can only explain so much, and then you find yourselves in these weird situations where you just never know what you might need, and if what you have already is going to be sufficient to get you through. Um, can guardianship exist in a single parent / divorced situation where both parents have custody of the child? Is guardianship, does it kind of, I guess, lends itself to that?
Yes, guardianship can be done when parents are divorced, separated, um, even, maybe there's just one parent involved. Um, the the situation to keep in mind is that if there's going to be a contested guardianship, right? So maybe one of the other parent is not in agreement. That's when you really need a legal attorney to assist you with that process. But I mean, there's some parents, we have clients that are divorced. One of them is remarried. The other one, you know, just has an amicable relationship, and they know that they have to do this for their son. So it can totally be done.
Right. Just so everyone knows, we're being joined right now by Amanda Ford, who's also a colleague of Catherine's at the Cuddy Law Firm, in case you're wondering who the person is on the screen. Welcome, Amanda. Please feel free to jump in on any of these questions. But yes, is there a minimum length of time that it takes to get guardianship, or that was the question that was submitted? Is there a minimum length of time for guardianship?
No, it is indefinite unless the individual with disabilities goes back to court and says, I don't need a guardian. And then, that would start a whole other proceeding, but it is forever long.
Kind of like, I hate to use this analogy, but kind of like a Britney Spears drawn out over years type thing, like that.
The conservatorship of Britney Spears is very different from like.
I know, I hated to use it in this context, but I was just like,
But it can, yeah, exactly. I mean, unless the individual says, I no longer need a guardianship, maybe because their disability changed with time, or I don't know, they may be a lot more independent. And again, that's why a lot of the courts, are sometimes even denying guardianships, because if it's not something that, like, if you can kind of tell that individual may be able to like potentially care for themselves, then maybe the court will say, you know what, this may not be appropriate, and maybe advanced directives and supported decision making are best. So
what is the cost of this process if you're going to get, I know there's certainly so many variables on what kind of legal support you might need, and also like medical evaluations to be completed, but do you have an approximation of what that might look like?
So I can't say what it would cost. The one thing I can speak of is with the Cuddy Law Firm, we do have individuals that are seeking guardianship assistance to do a consult with us. Now, the one thing is that these consultations are very holistic and approached very holistically, in the sense that we touch on everything, right? So I won't just speak to you about guardianships. I'll touch on everything else that, regards to like special needs planning, because, and that can be a whole other presentation for you, JC, but, sometimes people don't really realize, especially when you have a child with disabilities, what comes into play, right? Whether it's government benefits, health insurance, estate planning, trust, establishments. Sometimes people say, well, I don't need a will, I don't have any property, but then they don't realize that maybe they have a pension or life insurance through their employer, whatever it may be. So we touch on everything. Literally, we touch on every single topic. So at least your time with us is worthwhile. It is a $500 consultation fee, and that is then deducted from whatever the retainer amount is if you choose to proceed with our services. That retainer amount, I cannot tell you what it is, because again, it's very tailored to what the situation is and what their circumstances may be.
We definitely have some more questions coming through. So yes, my brother has some mental challenges, and I've been handling all of his medical decisions so far. He's 35 years old. Should I apply for guardianship, or is a healthcare proxy form good enough?
So again, it depends. That's a very specific matter. It would depend what the brother's capacity is and needs really are.
Okay. And then a parent asks, my child turned 17 on the 6th of December. Happy belated. Do I need to start the process, or do I need to wait? I think you said starting it.
Yeah, 16, 17 is it's a good time to start. You want to try to avoid that gap between minor and adult.
Okay. And then we have a question here. Can an individual who's under a guardianship, can they have a license to drive in New York City?
Yeah. If they have the ability to do so.
Right. How can we contact you? We will provide, the question is, how can we contact you for a consultation and how much is the charge? You just said it was $500, is that correct?
Yes.
It's deducted from the retainer, and we'll provide Catherine's, the Cuddy Law Firm's contact information in a follow-up email. It's also included in her presentation that she's given us today. Question here, and I don't want to go off too much on a tangent because you're right, this could be a separate presentation in and of itself, but can you talk a little bit about ABLE accounts?
The ABLE accounts.
Yes.
So ABLE accounts are bank accounts, right? Like custodial accounts that are established for individuals. Sometimes the courts will need to grant you access. For example, if you don't have like guardianship of the property, may need to grant you access in order to establish an ABLE account. There are some pros and cons to the ABLE account. And so you want to keep that in mind, right? That the ABLE account has its pros and cons. Sometimes there's a certain amount of assets that the ABLE accounts can hold. There is a payment back to the state that may be involved. So yeah, I mean, I don't know how much you want me to go into it.
Yeah, there's so much that we could talk about in terms of an ABLE account. But it is an account that's out there that exists to support specific individuals with disabilities, and to also prevent them from jeopardizing their own government benefits that they might receive in terms of SSDI and other benefits like Medicaid, in terms of waivers that also might jeopardize their ability to receive OPWDD services and all of that. So it's something that's created there. And also if that individual wishes to work, it also permits them to put money into an account, also for the parent or the guardian to put money into an account. There are a number of things that we could talk about with an ABLE account.
You can't have like 100,000 a year,
right.
Or it can affect them, like if that individual is receiving like means tested government benefits, such as like SSI, right, supplemental security income. You can't contribute more than like 15,000. There's some pros and cons to it, and you know, again, it depends on like why you want to open it. Like depending how much of the assets are involved, then you can consider, you know, first party trust, first party supplemental needs trust, or third party supplemental needs trust. So it's a whole other presentation.
It's a lot. I will say we do have a presentation on future planning that includes discussion of the ABLE accounts available in our virtual library, on our website, on Facebook, our Facebook page rather, and also our YouTube page. You can look at that. It is in English and Spanish, two separate presentations. If you wish to view that, I will share that in the link. We do have more questions though, and I want to make sure we cover them while we have you. Do I need guardianship to get a passport for my son who is 19 years old?
That I don't know. I mean, is the individual disabled?
Right.
I mean, probably to apply, being if they're like disabled and you're, you know, maybe. I don't know, to be honest.
Mm-hmm. Question: are there any places where we can get free assistance with guardianship?
So free assistance with guardianship, I mean, you know, some agencies like Synergy, I don't know how much, I mean, back in the day, I know that sometimes there was some support. Use some good, you know, information, but really I would contact the court directly. They're not going to charge you for speaking to you.
So contact the court and ask to speak with the
court clerk, surrogate court clerk, yeah.
And the court also has a do-it-yourself program where it'll ask you a bunch of questions. You complete the information and it'll fill out the forms for you, which is really helpful. But the court clerks are there to help. So I would ask them any questions you might have, but I can send you the link if you want to share it, of the do-it-yourself program through the court system.
That would be great. Thanks so much, Amanda. We do have a question. I would like to do the guardianship after they're, no, can the guardianship be done after they're 18? I want to do it, but I don't have a legal immigration status. Maybe my case is already being processed. Do you have any advice for a parent that doesn't have legal status on how to do this?
You can, again, you could definitely petition, but I can ensure that you won't hit a little bit of, some obstruction from the courts on proceeding with the guardianship. Like I mentioned, a Bronx County matter that we had, the parents were in the process of filing for their citizenship or residency. I can't remember right now, but the court, kind of rejected their petition and said, repetition with someone who's a citizen.
Mm.
So then they sought the assistance of an individual, that a family, a relative that was a citizen. Again, you can try it. There's no guarantee. And again, it depends what county you're petitioning in, because I feel like some counties are a little bit more curious about the immigration status than others.
Right. And to answer the first part of that question, you did say that after 18 is fine as
That's
well.
fine.
Yes. Question here. Did you say someone who is a ward can still get married? I thought they were unable to.
Yes. Someone that you have guardianship over, they can still get married if they want to. I mean, listen, you can have a whole other conversation about their capacity to understand what marriage is and, whatnot. But yeah, they can definitely get married. They can procreate, they can vote, all their constitutional rights remain.
Let me ask you, and this is an interesting question because I'm not sure if you're aware, but Synergia is one of the network partners of Project Shine, which is a group of network organizations, community-based organizations here in New York City, focused on developing tools, innovative tools for people with intellectual and developmental disabilities. And one of the things that we've been discussing in our group is, just like legal rights of an individual with developmental disabilities, and they fall under guardianship. Can they date? Does the guardian get to dictate who they can see, when they can see? Does the guardian also replace the individual's ability to consent? Questions of like that nature. So it's just, can you offer any insight into that, since we're talking about marriage and their legal constitutional rights, like to still kind of,
Yeah. So again, I mean, there's documentaries on this, right? And so much on like individuals. Some of them reside in residential facilities, and I mean, they may not see marriage the same way that you and I would see marriage, but they may see it as, like a companionship more than like another type of situation. Maybe they don't associate, certain behaviors with being married to the other person, right? So, but there are documentaries. I remember going to a conference in Florida and watching some videos about these individuals that were developmentally disabled, and their parents, they met at some residential facility, and their parents agreed for both of them to get married, and they lived with one of the parents. So like, in the household. And I guess, again, it's kind of protecting that individual and making sure that they're not being taken advantage of, right? Like if your son or daughter is being proposed to by maybe someone who you suspect may be that may be abusive to them, or that maybe is getting like wants to marry them to take advantage of them because maybe they know that, they're going to inherit X amount of money married to this person, then you can have a little bit more say. But if it's, for example, like a situation like I described, right, and like these documentaries, like two disabled individuals that, they just like hold hands and they claim to be married and, you know, love each other, then that's okay. I think that's in a situation like, you know, the one that's trying to take advantage of the disabled one. I think that's when you can be a little bit more involved and indicate this person doesn't have capacity. These are very like specific issues, right? And sometimes you have to look at them very individually. And JC, because, you know, it's kind of like, it's like going back to law school, like these case, you know, these learning case laws, cases that you learn, you study, and, you know, it's like, well, the 20-year-old trying to get married with, you know, the 90-year-old because they know they're gonna die soon and then they'll inherit. An 81 guardianship in that situation may say, well, no, this is not like a real marriage. Like that 20-year-old really doesn't love the 90-year-old. They're just doing it for the benefit, right? So you
There's a
have
lot there. Yeah, there's a lot there to sort out before you
there's
could
a
get.
lot to sort, exactly.
We do have one last question. It seems it's a follow-up actually from the passport question. Would I need to put my son's father's name on the application if the father's never been there for him?
Yes. This is a great question because if you don't know the other parent's whereabouts, you have to provide the court as much information as you know. And in some instances, you have to make every effort. And again, I mean, Amanda knows this. We had a case that the petitioner believed that the father of her daughter was in Mexico, or first she thought he was in Mexico, then she learned he was in Texas. So then being that he was within the United States jurisdiction, I had to contact the court and the clerk, and I had a conversation back and forth. She spoke to a supervisor, she got back to me, whatnot. And it was like, do we have to put out notice maybe in the newspaper in Texas that, you know, this person is filing for guardianship of this individual, to kind of do, you know, our due diligence. The clerk said, you know, it's okay. Indicate every step that's been taken to try to get a hold of this person. I mean, she was a, you know, pretty willing parent that had some contact with his family, and she tried, but it was impossible. So we had to file an affidavit. But his information had to go on the petition, and as much information as we knew from him.
Only because he was on the birth certificate, though. If the father's not on the birth certificate, then he's not required on the actual petition, because we did have that one case where there was a sperm donor. There was no other parent on the birth certificate. It was just the mom. So that was sufficient enough to include just the mom's information.
Yeah,
Wow.
there was a sperm donor.
Okay.
But we had to submit an affidavit for that one too.
Yes, I think so, explaining like the situation.
Mm-hmm.
So much, both of you, for this presentation and for answering our questions. Yes, one of our members from the audience is looking forward to that link, Amanda, for the do-it-yourself. So yes, I'll follow up within 48 hours, typically, of these presentations with all of the information that we've covered and additional resources that we've explored together. But I want to thank both of you, Katherine and Amanda, for joining us this morning and for answering all of our questions. It's been really insightful. And very interesting to see where the conversation has gone today. But yes, if there are any other questions, please ask them now so we can cover them while we still have a few more minutes. If not, I will go ahead and activate a poll and ask that you complete that. But yes, let me just check Facebook and make sure there's nothing there. Looking good and good here. All right, so I'll go ahead and activate that poll. Can you share the link? Do you have the link to the clerk's office now, Amanda, by chance?
Yep, I'll send it.
Okay, we're going to include that in the chat. So yes, thank you so much, everyone, for being here and for your time today. If you're interested in some upcoming events here at Synergia this month, let me copy and paste that for everybody. Hold on. There it is. We just posted the website information for the court's do-it-yourself program for 17A guardianships. But yes, so this month, we're doing a series with the Department of Education on specialized program within specialized education or special education here in New York City. The one on this week for Thursday will be over the ACES program. Next week will be over the ASD, Horizon, and NEST programs. And then we will have the week of Christmas, we'll have the AIMS program through the District 75 office. And then we will also host an information on the vaccine and the Department of Education policies. We'll have a leading pediatrician from NYU's Langone over that to cover the medical aspects, dispelling myths and misinformation, also dispelling the public charge. We'll also have one of our leaders from the Department of Education, Special Education Department, cover how the New York City Department of Education is covering this on their end. So that'll be over the next few weeks. Please check out our calendar. I'll send the flyers in the email so that you don't have to keep up with it. And I will go ahead and activate that poll now. Ladies, if you want to go ahead and take off, please, I'll touch base with you soon. And thank you so much.
Well, thank you to all for participating, and thank you, JC.
You
Wish
bet.
you all happy holidays.
You too. Thank you so much.
Bye-bye.